Hi everyone. Those of you who have managed to join already, we're pretty much right on schedule, so we'll get a start. For those of you who don't know and can't read on the screen, my name's John Vanderpoel. I'm a partner at Holman Webb in the general insurance team. Thank you for joining me for 2022, a year in review, which is another of the series of these presentations that we've done each year, where I get to indulge in looking at only the cases I really want to look at. So hopefully they're of interest to other people as well. We're going to look at 4 cases today, which have been in appellate jurisdictions of one sort or another. Firstly, the decision of the High Court, which Holman Webb successfully ran in Delor View Apartments and Allianz. Then we're going to have another look at. Then we're going to have a look at another case we successfully ran in the New South Wales Court of Appeal of Russell and Carpenter. We haven't looked at any cases that we weren't successful in because there weren't any of them, or were there? And then we're going to have a look at the Federal Court of Appeal decision in Avant and Darshn dealing with notification under Section 40 of the Insurance Contracts Act and the duty of utmost good faith. And finally, we'll have a look at the High Court's decision in Tapp and I think I can never remember the full name, but Australian Bushmen and Rodeo Association or something of that nature, which deals with recreational activities and a very catastrophic injury, unfortunately, in that case. So we might get started with Delor View. Okay. So, excuse me, Delor View is the body corporate for a complex of 11 apartment buildings, each containing approximately 6 residential lots. So located in Cannonvale in North Queensland, which is of course notorious for being exposed to cyclones. And sure enough, on 28 March 2017, Tropical Cyclone Debbie struck North Queensland and it caused substantial damage to the Cannonvale apartment buildings. 5 days before the cyclone, and perhaps thankfully, Delor View had obtained a policy of insurance with Allianz through its subsidiary underwriting agency, or through its underwriting agency, Strata Community Insurance. Prior to entering into that policy, Delor View knew that the Cannonvale apartment buildings had serious non-structural defects, but they didn't disclose those matters to either Allianz or SCI when they entered into the policy. Shortly after the cyclone, Delor View notified a claim under the policy. On 27 April 2017, following provision by Delor View of all the relevant documents to SCI concerning the claim and the pre-existing defects, an officer of SCI sent an email to Delor View's insurance broker referring to the non-disclosure and advising that SCI would need to investigate it further before making a determination. Shortly thereafter, on the 9th of May 2017, and this is an email that pops up repeatedly in the High Court decision, SCI sent an email to the body corporate's insurance broker, which stated in part, despite the non-disclosure which is present, that is the non-disclosure of the serious non-structural defects, SCI is pleased to confirm that we will honour the claim and provide indemnity to Delor View in line with all other relevant policy terms, conditions and exclusions. So a reasonably unqualified extension of indemnity, save for the operation perhaps of the one exclusion which was relevant to this claim, that the policy did not cover loss or damage caused by non-rectification of a defect that the insured was aware of or should reasonably have been aware of. So 1 year later, the solicitors for the insured wrote to SCI complaining about a number of matters, but most significantly perhaps because of an opportunity for SCI and Allianz to do something, was the complaint of the failure by Allianz to state its position on indemnity with any clarity. SCI did take that opportunity to provide some clarity, and it responded to the insured by asserting that despite the non-disclosure, which it said would otherwise entitle it to refuse to pay the claim in its entirety, it would pay for the cost of repairing certain of the damage that had nothing to do with the pre-existing defects. Now, those the cost of repairing those matters was $918,000, but the offer that excuse me, the offer that SCI made was subject to a requirement that the insured would pay for and arrange repair of the pre-existing defects, which amounted to $3.5 million. Allianz told the insured that if it didn't accept the offer, Allianz would decline to pay anything at all because of the non-disclosures. And perhaps having regard to the outcome in the High Court, the insured may now be regretting not accepting that offer. The matter proceeded at first instance before Chief Justice Alsop in the Federal Court in May 2020, and the decision of Chief Justice Alsop was that by reason of estoppel, waiver, and if necessary an injunction to restrain the conduct of Allianz with respect to breaching its duty of utmost good faith, he effectively found in favour of the insured. The matter went on appeal to the Federal Court of Appeal in July 2021 before Justices McCarricher and Colvin. Justice Derrington was the dissenting judgment, and Justice Derrington would of course be familiar to many of us as, I believe, related to the author of the Bible for liability insurers, Law of Liability Insurance in Australia. The appeal was however dismissed, and following an application for special leave to appeal to the High Court, the High Court eventually heard the matter. Chief Justice Kiefel and Justices Edelman, Stewart and Gleeson, with Justice Gagler dissenting, the majority of the High Court allowed the appeal. Now, there are a number of different bases upon which the insured pursued the proposition that Allianz was not entitled to rely upon the defence under Section 28(3) of the Insurance Contracts Act for non-disclosure. Obviously, the insured's position was that the extension of indemnity that was originally extended in May 2017 could not be resolved from by Allianz. So, as I say, the High Court considered a number of different heads. Firstly, waiver. Secondly, extinguishment of rights. Thirdly, estoppel. And finally, a breach of the duty of utmost good faith. As to the question of waiver of the Section 28(3) defence, the High Court said, as you can see there, aside from circumstances where a legal right can no longer be enforced due to the entry into a deed, which I might add substitutes for consideration, or, as the High Court said, a fresh agreement for consideration, or the expiry of a limitation period. In that respect, see the Wayne and the Commonwealth, which was and perhaps still is, the leading authority on estoppel. The High Court said the general rule is that despite a mere naked promise not founded upon any consideration not to enforce a legal right, the legal right may continue to be enforced until it is fully satisfied. So that in this case, Allianz was entitled to resolve from its promise to indemnify and was entitled to rely upon the Section 28(3) defence. The next topic, which the High Court referred to as extinguishment of rights, which is really waiver or election, was comprised of two different circumstances, the High Court said. One is where a person completes the exercise of a legal power to extinguish a right or set of rights, such as a power to terminate a contract in the future or to rescind a contract from the beginning. The alternative is where a person takes a course of action that is inconsistent with the continued existence of the right or set of rights. Those were the two areas which the High Court felt constituted extinguishment of rights, and they said that what Delor View was trying to do was to create a novel third category where the person's rights are extinguished by the person merely taking some steps which evidence a choice between two inconsistent courses of action. And the High Court said that the actions upon which Delor View relied are no more than actions consistent with, but weren't necessarily conclusive of, Allianz maintaining a continued intention to waive the defence under Section 28. So the High Court said that that novel third category was A, not a category, and B, hadn't been established in any event. On the third point of Estoppel, as many of us would know, in order to establish Estoppel, an insured, or anybody relying upon Estoppel for that matter, has to have evidence of and prove that it suffered a detriment as a result of reliance upon the representation, in this case, as a result of reliance upon Allianz's original May 2017 email. Now, the insured approached this on effectively two serious bases. The first was it tried to argue that it had lost an opportunity to have compromised the litigation with Allianz on terms more favourable than the offer that had subsequently been made by Allianz. So in between the initial extension of indemnity and then the subsequent withdrawal, they said that they could have settled it better if Allianz were not allowed to withdraw that offer, and that was their detriment. Now, the High Court rejected that argument. It said, for a pretty good reason, it said the first time that argument had been run, that is, that it had lost an opportunity to compromise the litigation better, was actually in the High Court. That wasn't an appropriate use of an appellate court, nor was it an appropriate time to raise it. And in fact, as I understand it, the insured had been invited by Allianz and the courts below to particularise its claim for detriment and its claim, and in that sense, its claim for estoppel, but had not done so. The further argument that the insured ran was that it had lost the opportunity to carry out the work itself. But the High Court said there was no evidence of what the work was, that is the repair work to the premises. And in any event, the evidence that was available was that the funds which were available to the insured at the time fell vastly short of what the cost of repairs in fact was, so that the insured would never have been able to undertake the work itself in any event. And further, the High Court accepted that, in fact, whilst there was no evidence of detriment, there was in fact evidence of benefit to the insured through repairs which had been undertaken by and paid for by Allianz, alternate accommodation which had been paid for by Allianz, and finally make-safe works that had been paid for by Allianz. The final basis upon which it was contended that Allianz ought be precluded from withdrawing, or be precluded from relying upon the Section 28.3 non-disclosure defence, was that it would run contrary to the duty of utmost good faith for Allianz to do so. The High Court said that that duty of utmost good faith as an implied condition, which is what the Act says it is, requires each party only to have regard to more than its own interests when exercising its rights and powers under the contract of insurance. Rights and powers must be exercised and duties must be performed, the High Court said, consistently with commercial standards of decency and fairness, as distinct from standards of decency and fairness in a more moral, general sense. An insurer and an insured, they said, do not owe a duty never to depart from representations made to each other. If such a novel duty were to be recognised, and if it were to add anything to the doctrine of estoppel, it could only be a duty not to depart without a reasonable basis from a significant representation concerning a claim. The High Court said that even if the the High Court said that when you read the 9 May 2017 email extending indemnity and the 28 May 2018 letter making the offer to the insured, when they're both read in context, the appropriate characterisation is that Allianz was merely giving content to its offer to pay what Justice Derrington described in the Federal Court of Appeal, a large gratuitous amount in respect of a liability which did not exist. And so the High Court further said that even if the novel duty proposed by Delor View were accepted, that is, that this duty of utmost good faith argument, the 28 May 2000 letter could not be a breach of the duty of utmost good faith because it was Allianz acting consistently with commercial standards of decency and fairness. So, in summary, an unqualified determination to extend indemnity can be changed, and I'd just add here, unqualified extensions of indemnity perhaps should be avoided if possible, and qualified extensions of indemnity subject to, for example, policy terms and conditions and subject to known facts and circumstances should perhaps be used instead. But the position made clear in Delor View is that any prejudice, is that the qualified extension of indemnity can be changed before there is any prejudice suffered by an insured, or before you have either a deed or consideration for the promise of indemnity, or a relevant limitation period expires. And just to re-emphasise the point, duty of utmost good faith does not require an insurer to disregard its own commercial interests, only that it has to act with commercial decency and fairness. There will be time for questions at the end, but if you pop them in the chat at the moment, Bill will make a note of them and let me know what they are. The next case is a case we ran in the New South Wales Court of Appeal, which involves a trip down these, or a slip down these stairs, and X does mark the spot where that occurred. Thankfully, we were able to get that image into the slides. So Damien and Vivian Russell were the owners of a short stay holiday rental property at the entrance. And that short stay property rental was a place that the claimant and some of his friends were staying at as part of a golfing weekend. And as part of a perhaps tongue-in-cheek presentation based on golfing results, the claimant was on the back deck of this property, which you can see in the left-hand side of that slide. He was given some golf balls, I think, as a prize. He dropped one and observed it bounce away down these stairs. As you can see in the photo, the stairs are helical in nature with 3 steps down. And the evidence was that as the ball of his right foot landed on the first step down, where the red X is marked, the claimant slipped on the edge. It caused him to fall feet first, such that he landed on his back and elbow, injuring himself. Mr. Carpenter said that the step felt slippery like ice, and he thought that the surfaces of the stairs had salt spray and mould or moss on them. The claimed cause of the slippery surface was later confined at first instance to be salt spray only. These premises were located pretty close to the beach, as I understand it. Mr. Carpenter sued the Russells in the District Court of New South Wales, and District Court Judge Strathdeed found for Mr. Carpenter and awarded him $284,000. District Court Judge Strathdeed found that the duty of care owed by the Russells included an obligation to ensure that the premises were safe and free of hazards, and to ensure that persons present could engage in ordinary social discourse and move around the premises freely without encountering any undue hazard. Perhaps unsurprisingly, the Russells appealed that decision, or their insurers on their behalf. The New South Wales Court of Appeal comprised of Justice Kirk, Marr and Gleeson, found that the District Court had fallen into error in stating the duty of care. The duty of care to the claimant, they said, as a lawful entrant on the property, was simply to take reasonable care to avoid a foreseeable risk of injury. And that's the classic statement of the duty from Australian Safeway Stores in Zaluzna from 1987. They said the obligation to the obligation to take reasonable care is to be contrasted with an obligation to prevent harm occurring to others, and furthermore that an occupier is not an insurer of the entrance onto the property, and that the reasonableness of an occupier's conduct is measured on the expectation that an entrant will also take reasonable care for their own safety. The court said that the risk of a person slipping and hurting themselves on the stairs was slight, inherent and obvious. The stairs they accepted were made from a material that the experts had agreed was safe and non-slippery even when wet, and there was no proper basis, regarding the way in which the case was run, for concluding that they were mossy. There was some evidence that another person had slipped somewhere else on the deck, not on the stairs, and sensibly the Court of Appeal found that that wasn't a relevant piece of evidence. And in fact, the respondent, Mr. Carpenter, seems to have slipped by his own human error in overstepping. The court said that the community standards of reasonable behaviour do not require households to eliminate all risks from their premises or to place a notice at the front door warning entrants of all the dangers that await them if they fail to take care for their own safety. And thankfully restated, or referred to, I should say, the decision in Wilkinson and Law Courts, which deals with stairs and often relied on by defendants in these sorts of cases. Stairs, they said in Wilkinson and Law Courts, are inherently but obviously dangerous. Many measures might have been taken to make the stairs as safe as human skill could possibly make them, but the duty is only to take care which is reasonable under the circumstances. Among the essential circumstances is the following fact: persons using steps may misjudge their footing and slip or trip, but this is an everyday risk which members of the public avoid by taking care for their own safety. Finally, there was a very significant argument in this case as to the presence of a handrail and whether one should have been there or not. The New South Wales Court of Appeal dealt with that in part through causation, because the plaintiff was holding golf balls in his hands and couldn't have used the handrail anyway if there had been one present. And furthermore, the suggestion that it would have provided a helpful visual cue was irrelevant, as the claimant was aware of the stairs and had placed his foot to the outer edge of the stairs in any event, so that handrail A wasn't required and wouldn't have made any difference. Brings us to Section 40 of the Insurance Contracts Act, and the next slide I'll do is Section 54. I just put these in here to give people a bit of a primer for Darshn and Avant, because it is really largely concerned with the operation of Section 40 of the Insurance Contracts Act and whether or not it is, well, it's concerned with Section 40 of the Insurance Contracts Act and the giving of notice under that provision to an insurer in circumstances where there's no contractual obligation in the policy to provide notice of circumstances. And this is obviously principally dealing with claims made and notified policies. Darshn and Avant, which we'll come to, deals with Section 40. It also deals with whether a solicitor appointed by the insurer can give that notice on behalf of the insured. And thankfully we've got a sensible decision about that. So Section 40 permits, by operation of the Insurance Contracts Act, notice to be given of a claim, notice to be given of circumstances which might give rise to a claim to an insurer, and if that notice is given as soon as was reasonably practicable after the insured became aware of those facts, but before the insurance cover expires, the insurer is not relieved of liability under the insurance contract merely by reason of the expiration of the contract of insurance where that notification has been given. Relevantly, in Darshn, as I said, there was no contractual obligation in the policy to give notice of circumstances that might give rise to a claim. If there had been, Section 54 might have made a difference in this case. And we all probably know the operation of Section 54 of the Insurance Contracts Act, but it's it's helpful to restate it before we get into Darshn. And it's the essence of it is that where the effect of a contract of insurance would, but for this section, be that the insurer could refuse to pay a claim by reason of some act of an insured or other person being an act that occurred to after the contract was entered into, but not being an act which caused the loss. The insurer may not refuse to pay the claim by reason only of that act, but can reduce the amount that it has to pay for the claim by the amount that fairly represents the extent to which its interests have been prejudiced. So Darshn and Avant, sorry, just bear with me a second. So between January 2015 and January 2018, Dr. Darshn performed breast augmentation surgery at the Cosmetic Institute, TCI. Dr. Darshn had been insured with Avant from 2011 to 2019, and those policies were obviously claims made and notified policies. However, none of the policies required contractual notification of circumstances that might give rise to a claim to be given to Avant. That made Section 40 of the Insurance Contracts Act and not Section 54 very relevant. There's a bit of a chronology of events. I'm sorry for the long list of them, which I'll show to you now. Hopefully. So as I said, in 2011, cover with Avant commenced, and breast augmentation surgery was performed by Dr. Darshn between January 2015 and January 2018. By June 2017, there was one complaint to the HCCC. March 2018, there was some proceedings commenced for damages, and McIntyre lawyers, referred to from here on as MDL, were appointed to act for Dr. Darshn by Avant. In January 2019, a subpoena was served on Dr. Darshn in a class action proceedings, and in February 2019, MDL informed Avant of the overlap between the first set of proceedings that have been commenced and the class action. In February 2019, again, Dr. Darshn phoned an Avant hotline regarding the subpoena which he had received in the class action proceedings. And we'll come to some more detail about what the consequences of that were, but Avant apparently didn't tell him at that time to notify them of circumstances having seen that subpoena. In March 2019, in another set of proceedings, there was a discussion concerning those proceedings and another subpoena. And in June 2019, the cover with Avant for Dr. Darshn ended. Unfortunately for him, in June 2020, he was joined to the class action against the Cosmetic Institute. Now, the correspondence from McIntyre lawyers described the nature of the TCI proceedings, or the class action proceedings, and the causes of action and common questions in those proceedings. It was held at first instance that it was apparent that some of the causes of action were potentially open against the surgeons such as Dr. Darshn. And furthermore, it was apparent that in circumstances where the Cosmetic Institute had been denied cover by their insurers and were in liquidation, and the liquidators had said they didn't have sufficient funds to satisfy any judgment against them, it was conceivable that the surgeons who had practiced at the TCI clinics and performed the relevant breast augmentation surgeries would be joined as defendants in those class action proceedings. Justice Mashinsky at first instance held that Section 54 did not cure, and that was an argument which was pursued, but that Section 54, absent a contractual compulsion to notify, didn't cure a failure to notify under Section 40. He said that the preferable construction of the provisions is that Section 40 and Section 54 stand alone as ameliorative provisions, and their operation cannot be confined so as to make a failure to notify under Section 40 capable of being cured under Section 54. So the matter proceeded to the Federal Court of Appeal before Justices Jaggett, Jerrington and Colvin. The key questions were whether, so these are the three key issues in the case, whether Mackinson-Dapchi had authority to give notice of facts which might give rise to a claim under Section 40 on behalf of Dr. Darshn, whether by the communications between Mackinson-Dapchi and Avant, did Dr. Darshn actually notify Avant of those circumstances under Section 40, and if he didn't notify under Section 40, was reliance on that failure to notify a breach by Avant of the duty of utmost good faith. And the arguments advanced on that issue by Avant were that these multiple ones here. Firstly, that MDL's retainer was limited to acting for Dr. Darshn only in respect of those two proceedings, not the class action proceedings or giving notice of circumstances. That Mackinson-Dapchi had been engaged expressly on Avant's behalf and not as an agent for Dr. Darshn in his dealings with Avant. Thirdly, MDL was appointed solely for Avant, and that pursuant to the terms of the insurance policy, there was an express provision that between Dr. Darshn and Avant that any lawyer appointed was by Avant was in its own capacity, that is in Avant's own capacity, and not as agent for Dr. Darshn. Finally, that the retainer of Mackinson-Dapchi for Dr. Darshn was a general, was not for Dr. Darshn generally, and that retainer wasn't sufficient to authorise Mackinson-Dapchi and the communications that they gave to Avant to provide any notification of circumstances. So there are a number of factors which the court considered in determining whether or not Avant's reliance upon the failure to notify was a breach of the duty of utmost good faith. And so one of those factors was the medico-legal advice service, which, as I said earlier on, did not inform Dr. Darshn that he ought notify under Section 43, despite being aware at the time that being aware of the nature of the class action proceedings, and also being aware that the subpoenas probably indicated that Dr. Darshn was likely to be joined to the proceedings, and in the knowledge that he could obtain the benefit of Section 43 by notifying of circumstances but not doing so. Finally, having seen similar, sorry, not finally, almost finally, having seen similar subpoenas issued to other surgeons, where the terms of those subpoenas really conveyed the possibility, if not the likelihood, of surgeons such as Dr. Darshn being joined to the proceedings. And now finally, having adopted a position with other doctors who were provided with a copy, who provided a copy of the subpoena to Avant, that Avant would treat the provision of the copy of the subpoena as notice having been required by, as being sufficient notice under Section 40 of the Insurance Contracts Act. Now, I should just go back for a second and say that, strictly speaking, the comments by the Federal Court of Appeal on the good faith issue were unnecessary, because they had decided that, unsurprisingly, that Mackinson-Dapchi's retainer was not limited to the matters which were contended by Avant. Rather, there was a solicitor-client relationship between Avant and Mackinson-Dapchi, and Mackinson-Dapchi's provision of information to Avant was sufficient to be a notification under Section 40. And perhaps more specifically, the notice that was to be given under Section 40 did not have to be in any specific format, didn't have to adopt any specific form of words. All it had to do was notify of circumstances that might give rise to a claim, and it did that. So that, as I say, it wasn't strictly necessary to go on to consider whether it was a breach of the duty of utmost good faith to have relied on the failure in notification, but it's pretty clear that the Federal Court felt that it was a breach of the duty of utmost good faith to do so. And the fourth and final case we're dealing with today is Tapp and the Australian Bushmen's Campdraft and Rodeo Association. I almost had it right when I said it. So it's a sad case in many respects for the claimant, obviously. On the 8th of January 2011, and this is actually a case that I dealt with, I think, in the 2020 or 2021 year in review, because it was just as interesting then, but now we've had the High Court give its determination of the matter. So on the 8th of January 2011, Emily Tapp, who was then 19 years old, participated in a Campdraft event at Elliston in New South Wales, and I'll come to what a Campdraft event is. The event was organised by the association, and during the course of the competition, sadly, she fell from a horse and suffered a significant spinal injury. Sensibly, the parties agreed quantum at $6.75 million. The plaintiff had been competing in camp drafting since she was 6. Camp drafting is a sport that involves a horse and a rider working cattle. In camp drafting competition, a rider on horseback rides into a camp containing between 6 and 8 head of cattle and attempts to separate or cut out one animal from the herd. The rider must first manoeuvre the cow 2 or 3 times back and forth across the camp to demonstrate some control over the animal, and the rider then calls for the gate of the arena to be opened, and after entering the arena, the rider must draft the animal around 2 pegs in a figure-8 course before finally guiding through another gate marked by another 2 pegs. Usually the competition is judged, obviously, and usually it lasts between 45 and 47 seconds. Unbeknownst to the claimant, there were 4 falls in this arena before hers, and a warning was given to the defendant after the first 3 falls that the competition should be stopped because the ground was getting a bit slippery. Okay. A second warning was given after the 4th fall that something should be done about the event because the ground was unsafe. This appeal to the High Court was from the New South Wales Court of Appeal, who had dismissed the claimant's appeal from the first instance decision, which also was not in her favour. So there were 3 key issues before the High Court. They were, as you can see there, the obvious risk of a dangerous recreational activity having manifested itself, identification of what that risk was, both as to the recreational activity defence and as to breach of the duty of care, and thirdly, an issue in relation to causation. So there was no dispute that the activity in which Ms. Tapp was involved was a dangerous recreational activity, but both Section 5B and Section 5L, which you can see my plotted summary of there, both of those sections require the relevant risk to be identified. And it was apparent that the real issue was the characterisation of the risk at the correct level of specificity. The trial judge characterised it as the risk of falling and being injured, or the risk that the horse would fall, and as a consequence of that, Ms. Tapp would fall and be injured. Now, the High Court said that characterisation of the risk was far too broad. They said the risk could be characterised as the substantially elevated risk of physical injury by falling from a horse that slipped by reason of the deterioration of the surface of the arena. The risk characterisation is the same for the determination of what the recreational activity is as it is for the question of what the risk is, as it is for the question of what risk it is the defendant is said to have been required to guard against. It was held that a reasonable person in the position of the association could have foreseen a probability that harm would occur if the competition were not stopped, and stopped or suspended, you'll see becomes irrelevant later on, until the defendant had inspected the arena to be satisfied that the ground was reasonably safe. The High Court said there was a likely seriousness of harm at a catastrophic level if that wasn't done, and the burden of taking precautions to avoid the risk of harm was the simple act of stopping the event to inspect the arena and consider the safety of the ground of the arena, so not particularly burdensome. And on the social utility question, the social utility of taking those steps were not outweighed by stopping the event. And this was particularly so as the claimant was not aware of the relevant risk. She hadn't been made aware that there had been 4 previous incidents, and that plays into the recreational activity defence because she was not aware of it. Now, well, at least the High Court said that was the case in relation to the recreational activity defence. The final issue that's worth considering is a concession that was made at trial by the defendant, and the concession that was made because the claimant couldn't identify, perhaps curiously because the horse wasn't able to talk like Mr. Ed. That's a flashback for a number of people, but perhaps missed by some. The horse couldn't talk, so couldn't tell anybody, and it was therefore impossible to prove what had caused the horse to slip and fall. It could have been the slippery surface of the arena. It could have been any number of other things which might cause a horse to slip and fall. The defendant had conceded, as I say, at first instance, that if the breach involved a failure to stop the event before the claimant's ride, then it is self-evident that the failure to stop the event was a necessary condition of the harm, and the requirements of Section 5D, which are repeated there below, are met. Now, the minority judgment of Justices Keegle and Keane held that that concession didn't operate because the case ran at trial was a failure to suspend the competition, not to stop it. The majority perhaps took a more pragmatic view of that concession and said that stopping and suspending in the context of the competition were pretty much one and the same, and in any event those terms were used interchangeably when discussing the need to inspect the competition surface. And accordingly, because of the concession, causation was established. That is the last slide. So I don't know whether there are any questions or not, but I'm happy to take them if people want to put them into the chat. I don't know if people can actually unmute themselves, can they, Bill, or not? No? Can't unmute yourself, sorry, but you can post questions in the chat.